Assistant Public Defender Natalie Pate with and on behalf of Mr. Havens, who stands to my right. Please state your name for the record, sir.
Matthew Havens. Thank you.
This case opens quietly, but don't let that fool you. What you're about to witness is a courtroom balancing act between accountability and recovery, between punishment and rehabilitation. Two defendants, two very different paths, one courtroom, and one judge tasked with deciding whether trust can be rebuilt or whether the system has run out of patience. We begin with Matthew Havens, a man already in trouble, now admitting he violated bond by drinking and contacting the alleged victim. In court, that's not a mistake. That's a breach of trust. Bond is conditional freedom. It's the court saying, I'll let you stay out, but you follow my rules. Break them, and the consequences are real. Then comes Holly Brown. Her story cuts deeper. She's battling long-term addiction. The court gave her a chance. She slipped. And now Judge Simpson must decide whether that slip is a reason to help her further or lock her away. These hearings aren't just about rules. They're about patterns, risk, public safety, and whether someone is truly trying to change or just saying the right words. Watch how the judge listens. Watch how the attorneys frame the struggle. And ask yourself, when someone breaks a promise to the court, should mercy still be on the table? Because in this room, every word matters, and every choice echoes far beyond these walls.
Thank you, Your Honor. Today is the date and time set for a bond violation as well as probable cause conference. As to the PCC, Mr. Havens will be waiving his right to a preliminary exam, and he is signing his waiver form as such now.
Bond violation.
Your Honor, we have been in receipt of the police report that, to our understanding, the allegations of the violations of bond are both a drinking event as well as contact with the complaining witness on the misdemeanor count. Mr. Havens does acknowledge and admit to both of those bond violations and asked to briefly address bond when appropriate.
So before I do okay, go ahead.
Oh, address bond, Your Honor. Thank you.
Yes.
Mr. Havens is respectfully requesting the court consider a PR bond with a tether. He does have family in Traverse City that he could either reside with or they could get him set up here. He does have work at Movable Feast in Manchester, Michigan.
This is a classic defense strategy. Humanize the defendant, stabilize the narrative, and reframe risk as manageable. We hear about family. We hear about work. We hear about structure, a tether, employment, stability. The subtext is clear. He's not a flight risk. He's trying. He can be supervised. But here's the problem. Mr. Havens has already violated the court's trust. He didn't just slip on paperwork, he drank. He contacted the complaining witness. Those are direct violations, and in the judge's world, those aren't technicalities. They're red flags. Judge Simpson isn't reacting emotionally. He's analyzing pattern. When he says this looks like more than a one-off, he's signaling something critical. Courts don't just punish acts, they evaluate trajectories. Is this person moving forward or repeating the same cycle? And notice the shift. The judge doesn't argue about tether logistics. He goes straight to substance abuse. That's the root. Because a tether only tracks location. It doesn't stop behavior. If addiction is driving the decisions, then supervision without treatment becomes a delay, not a solution.
He started about a month ago. He indicated to me he's missed 3 days of work since being in custody. He is not on probation or parole and was not at the time of this alleged offense. This is his only felony case pending, and he is asking the court to consider a release on a tether at this time.
Your Honor, I have to say that I'm concerned based off of the violation, not just with their contact, but there was drinking. It seems to me that this is more than just a pattern, but a pattern of abuse in the sense of substance abuse. I am significantly concerned that if the defendant were to be released on a PR, that we would continue this pattern. I am nervous about having him released and fail. I think that there needs to be some form of treatment or assessment in place at this point.
So you're waiving your right to a preliminary examination?
I am. Yes.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes,
And you understand you'll not have that hearing and that you'll proceed to circuit court
correct.
for the resolution. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with count 3 following.
Thank you, Your Honor. We acknowledge receipt of the information. My client stands mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
September 4th at 1:30 before Judge Conlon.
September 4th, 2024, 1:30 before Judge Conlon. What I am going to do at this point in time regarding his bond, him having admitted to the bond violations, as I read it, I mean, you got other issues certainly, but as I read it, I think the significant issue is your substance abuse, which is leading to a number of other things for you.
This is a quiet but firm judicial line in the sand. Judge Simpson isn't moralizing. He's diagnosing. He's saying your problem isn't court, it's control. And that matters, because once a judge frames your behavior as systemic instead of situational, the court's role changes from managing logistics to managing risk. Notice what he doesn't do. He doesn't lecture. He doesn't shame. He doesn't threaten. He redirects. Put something in place. That's judicial language for show me change, not promises. Treatment, assessment, proof. Courts don't operate on hope. They operate on evidence. In criminal procedure, bond is a privilege, not a right. And once violated, the defendant bears the burden. The court doesn't have to gamble again. The defendant has to earn it back. This moment sets the tone for everything that follows. Because what we're seeing isn't just one man losing a bond request. We're seeing how the system reacts when behavior contradicts intent. Words say, I'm trying. Actions say, I'm repeating. And that tension between what people claim and what they demonstrate is about to become the heartbeat of this entire hearing.
And so at this point, I am not going to reduce his bond. I would suggest maybe before you get before Judge Conlon and make that request that something be put in place for him to address that concern.
Yes, Your Honor.
So at this point, bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
For the record, Erica Julian appearing on behalf of Holly Brown. Holly, state your name. Holly Brown.
Okay. We've seen our bond violation report.
Yes, Your Honor. And and she provided a letter to the court. I'm not sure if you were. I have another copy, Judge.
Is that with?
I had provided it to your staff with the file as it was going back, but I'm not sure whether.
Yeah. Oh, there.
Yes, sir. Yes, Your Honor. So I'm not sure. We do have a plea agreement in this case, and the way that we came to the plea agreement, discussed at the time that it would be an appropriate resolution based on the factual and legal issues of this case. I know that separately there's a bond violation for us to address with the court today. I wasn't sure in which order the court would be willing to hear them.
To do what?
To either take a plea or to address a bond violation.
Well, I'm a bit reluctant at this point to take the plea because of the bond violation. I'm also, I will say that, I mean, what should happen here, right, frankly, is you should be remanded because we've been through this. So I read your letter. Tell me why I shouldn't do that with you.
This is the moment where the air in the courtroom changes. You should be remanded is judicial shorthand for you've crossed the line. It's not a threat, it's an assessment. From the court's perspective, a bond violation isn't symbolic. It's predictive. It tells the judge what may happen next if nothing changes. Holly Brown's response is raw. She doesn't deny the violation. She doesn't deflect. She owns it. But ownership alone isn't what courts evaluate. Judges measure risk. And addiction complicates that equation because remorse doesn't stop relapse. Sincerity doesn't prevent harm. What Judge Simpson is wrestling with here is the central paradox of addiction cases. Is this person choosing to disobey or failing to control something they're actively fighting? The law is built around agency. Addiction blurs that line. From the bench, the judge has two obligations. One is to the defendant, the other is to the public. Compassion cannot eclipse safety, and safety cannot ignore reality. This is why he asks her to justify freedom, not emotionally, but practically. Why should the court trust you again? And that's the question that defines this entire segment. Not, are you sorry? But, what is different now?
Your Honor, I feel absolutely horrible. I sat right here and I cried when you allowed me to be released and gave me another opportunity upon. And I know that I violated that and I am owning that, but I did not do anything. I didn't get behind a wheel. I didn't do anything to hurt anyone or myself or any property.
Well, it does hurt yourself.
And exactly,
It does.
it did, and it does hurt me. But I physically or to anyone or anything, I just want to say that it was a nonviolent act, and I know it was wrong. And right now, I am building from ground zero back in my life, and I'm really making strides. Although this violation does not indicate that. 87 out of the 88 last days that I have not had dropped to drink.
What happened? What happened that day? I mean, what happened?
Can I just help facilitate just for a moment, Judge? We had a really long talk about this yesterday, and I was very blunt with Ms. Brown. And just from my initial perspective, and then if she wants to explain further, when she was in custody for 2 weeks and her La Casa advocate was here, we never did get to the bottom of this other thing. And I think we probably would have not worried about it a whole lot, but for the fact that you stepped down from a scram to a sober link, and then she had a positive blow on Tuesday. So when she was released, her La Casa advocate was here in the courtroom and, did continue to assist her. But by that time, they had given away her bed. And that is common and that happens. She went to stay, and she explained all that in her letter, what she did subsequent to that. She's been trying to get back into La Casa. I met with her and her La Casa advocate yesterday. They're anticipating that a bed will be open anytime. And she's been staying in a motel. But what that has to do with it is, honestly, she was doing so well in this entirely structured setting. And when she was released, she was unable to return to that same structured setting. And I think it just fell apart on her.
This is one of the most honest defenses you'll ever hear. No theatrics, no denial, just context. Structure kept her sober. Chaos broke her. That's not an excuse. It's an explanation. And in treatment-oriented courts, explanations matter. The attorney reframes the violation not as rebellion, but collapse. When the support system vanished, so did stability. That matters because it shifts the narrative from defiance to vulnerability, from won't comply to can't maintain without scaffolding. And listen to how addiction is described. 25 years, a go-to, a reflex. This isn't a weekend habit. This is wiring. Courts are often ill-equipped to deal with that depth. The law is binary. You comply or you don't. But addiction isn't binary. It's cyclical. What the defense is really asking for is time. Time for a bed to open. Time for the structure to return. Time for the relapse not to become a death spiral. The judge now has to decide whether the court becomes a bridge or a wall. Ask yourself, if someone is inches from help, does the system pull them back or push them forward?
And I understand everything that Your Honor had said to her previously. If I could, I don't think she even knows that I know the steps. I think she's, based on yesterday, this is a huge step one issue. Meaning first step of the program, admitting that she's powerless over alcohol and that her life has become unmanageable. This is one of the instances that often folks point to and say, see how unmanageable that made your life become. And I know she is grappling with her, she wants to be sober so badly. she doesn't want to be this person or someone who walks into a liquor store and buys alcohol because that's a go-to. It's been her go-to for 25 years, and she's tried very hard to put it down. And this is me coming to Miss Brown, accepting her cases on appointment, not knowing anything about her, and initially probably having the same view as everybody else, but getting to know her. I understand that she is trying so hard to keep it together, and where it may seem simple, to just simply not consume the alcohol. I know that she struggles every day with all of her past trauma, everything that's happened, everything going on presently. And it is hard for her to keep it together when she is not in a structured environment. And I really don't mean the jail, because I understand that's the next step for her. But she's within just inches of being able to come back into La Casa in that structured environment. And she went to meetings the last couple of days. She went to a meeting yesterday. She was not able to make it today. That's just due to a number of circumstances outside her control. But she is continuing to go to meetings every day. So that's my 2 cents for Miss Brown.
Anything you want to add?
Your Honor, I feel that being in an environment where I'm supported and structured, as opposed to being locked away for something that I'm not a threat to society for, that I will make much.
Hold on. Ms. Brown, but you are.
I hear you. I do. And I'm sorry.
Because, you know, when you say you're not a threat, you're drinking, you can't control it, right? And, you know, like you said, I mean, this time you didn't get behind the wheel, but what if you do? And at least 3 times before, 2 times before, maybe a third, you did.
This is where empathy collides with reality. Judge Simpson isn't arguing her intentions. He's confronting outcomes. What if you do? That's the judicial lens. Courts don't operate on best-case scenarios. They operate on worst-case consequences. He acknowledges her pain, but he reframes the harm, not just to herself, but to others. Because addiction doesn't exist in a vacuum. One relapse can become a tragedy. And judges carry that weight. Every release carries risk. Every risk becomes the court's responsibility. Her response is heartfelt. She doesn't want jail. She wants treatment, support, community. That's reasonable. But courts can't substitute hope for safeguards. This exchange reveals the tension between therapeutic justice and traditional enforcement. Is jail a failure or a pause? Is structure only valid if it's voluntary? Judge Simpson isn't dismissing her struggle. He's asserting the court's role, prevent the preventable. The question becomes not, does she deserve help, but can the court afford another mistake? And in that silence between those two truths, a decision forms.
Right now, I am understanding. I'm desperate to be in a better place than I'm at. And the way to obtain that is not by being locked in a jail, but by being in a supportive environment with therapy and with support through AA members and therapists and counselors and advocates, and being surrounded by people who are like-minded in the desire to stay sober and to better their lives. And that's where I am. I don't want anything worse for my life, but I don't think I'm going to be able to start building that sitting down there, over there, where
Down that way.
And I honestly, I mean, the days that I have put in and the time and the work that I have put in, I think does show that the mistake that I made was huge. And I do not deny that, and I'm not minimizing it, but it's just a setback for me. It's not anything that's going to be productive. It's just going to just punish me for something I'm already kicking myself for, Your Honor. That's all. May I add, as far as driving, I do not have access to a car. And this last offense that we're initially here for, the Secretary of State did take my license at that point for 2 years. And that was 1.5 years ago. I have had absolutely no, I've not been behind the wheel, and I have not had any, I've had proof of that by not pulled over or having anything. I was not pulled over because I wasn't behind the wheel, but I also wasn't, there's been no traffic violations for me since then. And that was before I knew of the charges that were brought to me. So I just wanted to add that. I do not have intentions of getting behind the wheel until I am legal to do so.
All right. Here's what I'm gonna do. I'm gonna switch you back to a scram, Tyler. I'm not gonna take your plea. I am gonna adjourn this out to the 19th of 1 month. With the admonition to you that you better hope it doesn't malfunction or anything along those lines. I'm not gonna be listening to any of that. All right? If there's any indication that you're drinking, what the court's gonna do is we're gonna come get you. All right, and I'm not gonna, Miss Julian knows me, and I'm not gonna hear a whole lot more at all from you.
Understood. So at this point,
So I'll adjourn it to the 19th, 9 a.m. or your Zoom invite indicate defendant is to report to community corrections before you leave here today, and you're to be placed on a scram, Tyler.
okay.
We are extremely thankful to you, Your Honor. Thank you.
Judge Simpson draws a narrow bridge between mercy and enforcement. He doesn't take the plea. He doesn't remand her, but he tightens the net. Scram isn't symbolic. It's constant accountability. It's the court saying, you get one more chance. But this time, there are no shadows to hide in. For Matthew Havens, the court demanded proof before trust. For Holly Brown, the court offered structure before surrender. 2 defendants, 2 outcomes. Same principle. Behavior determines freedom. This hearing isn't about punishment. It's about trajectory. Courts don't exist to rescue, but they also aren't blind to struggle. What you saw today is the justice system trying to decide whether intervention can replace incarceration. And that question doesn't end in this courtroom. It echoes everywhere addiction meets accountability. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.